Imagine inheriting a fortune worth millions, only to be stripped of it because of what your family deems a lack of achievement, and then getting hit with a legal bill that could bankrupt you. That's the dramatic reality facing William Seymour, the Earl of Yarmouth, in a case that's got tongues wagging across the aristocracy. But here's where it gets controversial. Is it fair for parents to judge their adult child's worthiness for an inheritance based on personal choices like marriage and career paths? Let's dive into this tangled family saga to uncover the details and see if you agree with the court's ruling. William Seymour, a 31-year-old nobleman holding the title of Earl of Yarmouth, had a serious falling out with his parents, the Marquess and Marchioness of Hertford, back in 2018. For those new to British titles, a Marquess is a high-ranking peer, just below a duke, and it comes with centuries of family history and responsibilities. William had recently tied the knot with Kelsey, who became the Countess of Yarmouth, but his folks weren't exactly thrilled about the union. In fact, he claimed they were far from delighted, setting the stage for deeper rifts. The heart of the dispute revolved around his father's £85 million estate, a sprawling legacy that includes the historic Ragley Hall, a majestic 400-year-old mansion in Warwickshire with 110 rooms, plus 6,500 acres of land featuring farms, woods, and parkland. Think of it as a mini-empire, passed down through generations with ties to Jane Seymour, the favorite wife of King Henry VIII. William had been led to believe he'd take over managing this estate once he turned 30, a milestone that came and went without the expected handover. Frustrated, William launched a high court action against the trustees, his parents, and his siblings, aiming to dismantle the trust structure and oust the trustees who, he argued, were siding with his family. He felt the estate's operations were mishandled and that his wife was being disrespected, like when she wasn't invited to trustee meetings. But here's the part most people miss. His father, Lord Hertford, testified that while he once planned for William to inherit, he reversed course because of his son's lack of achievement. Specifically, he noted that William attended college but dropped out without graduating and hadn't pursued a profession or gained the qualifications needed to run such a vast property. The marriage to Kelsey was cited as a factor, but not the primary one. The judge, Master James Brightwell, sided with the trustees, ruling they hadn't acted improperly despite the tense family dynamics. He acknowledged the deep antagonism toward Kelsey, evidenced by Lord Hertford reportedly urging his son to call off the wedding on the big day, but deemed William's grievances about estate management unfounded. As a result, William lost the case and now faces a whopping £1.3 million in legal costs, £717,000 from the trustees, £330,000 from his family, and over £300,000 for his own lawyers. He's been ordered to pay £500,000 upfront, with the rest to be decided unless the parties settle. This ruling raises eyebrows about family expectations and inheritance rights. Should bloodline alone guarantee a share of wealth, or is it reasonable for parents to withhold based on perceived life choices? And what about the role of marriage in these old money families? Does a spouse's background really justify such animosity? We've seen similar debates in cases like the Rockefellers or even modern celebrity inheritances where achievement is subjective. Do you think the judge got it right? Or is this a case of parental overreach? Share your thoughts in the comments. Do you side with William, his parents, or the courts? Let's discuss.